Everyone, welcome back to a series of discussions that Frank Ravitch and I are having around some of the major cases in our casebook, Law and Religion. I hope you've been enjoying them. To get right to it, today our topic of discussion is one of my personal favorites, and I think maybe Frank's too, although we will see, Lee versus Weisman, which I find to be a very funny case, but also a lot of fun to teach. By the end of this, if I can't get my students to laugh, it's just I haven't done my job. But anyway, so we're going to talk to Lee about Lee, not to Lee, about Lee. And I want to start off with always my favorite question. And this is, it's amazing what you can get, what you can squeeze out of an eighth grade graduation. The first time I read this case, I went back and I said, oh my God, I really missed a life-altering event because for the life of me, I cannot remember my middle school graduation. But putting that aside, that just was the beginning for me of the hilarity of the case, that and what I call the supermarket approach to the hunt for, and in such a typical American way. Remember, I'm the internationalist. Right? In such a typical American way, you want standards? We've waited 15 years to get you one. Don't worry, we're Kellogg's. We'll get you not one standard, not two, not three. I'll give you 4, 5, or 6, and off we go. But anyway, so Frank, how do you approach the case? What do you think?
You know, there is a sort of underlying question of, you know, what happens when 2 tests are not enough, right? So going into Lee, you know, we already had from Abington Township v. Shemp, we had the sort of the first 2 prongs of the Lemon test, and by the time Lee came around, the Lemon test from, you know, had the 3rd prong, although that's rarely relevant in graduation or in prayer cases in general. So we had purpose and effect. We also, by 91, the court had adopted, really by 87, the court had adopted the endorsement test, right? So you think, okay, we've got, is it going to be a problem under endorsement, or is it going to be a problem under Lemon, or both? And so a lot of people thought, well, maybe they'll clarify which test applies, and what we end up with. And part of this is I think it's important for people to learn. We've seen this in recent cases like Fulton, where, you know, in a law and religion case, and particularly in a case that's on what might be viewed as a culture war issue like school prayer, the more justices you can get in the majority, in a relatively unified majority opinion, the better in a way. And so, you know, Justice Kennedy, who was never a fan of Lemon or endorsement, came aboard with now the 3rd test, this indirect coercion test. Now, he didn't say, the opinion doesn't say that Lemon and endorsement should be avoided. What it says is, and this is very important language, at the very least, you cannot engage in a government directed religious exercise during an important event, right? So it's essentially that at the very least language is saying, well, Lemon and endorsement very well might still apply, but you know, Justice Kennedy authoring the opinion was not going to go there. We know the concurring opinions went there, and for those of you who are interested, it's a step-by-step guide as to why this prayer violates the Lemon and endorsement tests, right? If you look at, you know, Blackman's concurrence, things like that. So you've got this,
as well as why it is indirectly coercive, and why that could be a constitutional predicate to the application of establishment.
Yeah, exactly. And we see this a bit in the majority opinion as well, but in the concurring opinions, we see this sort of discussion taking it back to Engel, which the majority cites as well, and saying that, you know, this notion of having these exercises, the fact that someone might excuse themselves doesn't prevent it from violating the Establishment Clause. Of course, the difference being that the concurring opinions make it very clear that coercion is not necessary, indirect or otherwise, is not necessary for an Establishment Clause violation. I think a lot of people miss, though, that the majority opinion, although it doesn't say it as directly, when it says at the very least you can't, the implication is there is more that, such as endorsement and lemon. So I always kind of start with that. You know, why do we have this indirect coercion test? Where did it come from? Why not just use, as the concurrences suggest, the tests that should pretty clearly dispose of this as unconstitutional? And but I think,
except of course, in the eyes of the dissent, that now begin to develop yet another test, right? The historical test that will lead to neutrality and accommodation, which is also there, although studiously avoided by the majority in the concurrences.
Yeah, and that's interesting as well. When we look at the dissenting opinion in Levy Weisman, what's fascinating there is we see these sort of I don't think the people who join the dissent would like the idea of penumbras, but we sort of see these almost penumbras of this tradition test reflecting back to to Lynch v. Donnelly, right, and Marsh v. Chambers, but also reflecting forward to cases like, you know, symbolism cases like Van Orden v. Purry, but also a lot of what we're seeing today in the 2020s under the Free Exercise Clause, and we'll see it in the case out of the First Circuit, the voucher case, whether that'll be applied as well in other Establishment Clause contexts, right, other than symbolism.
All right, but I before we leave coercion, I love doing this in class, so I'm gonna do it to you too. The majority goes out of its way, and you know, and we understand why, to develop this coercion test. And Scalia does his best in one sentence to utterly destroy the entire notion of coercion as nothing more than a form of corruption of the term to make it effectively incoherent. The coercion was a hallmark of historical establishment of religion, was coercion of religious orthodoxy and financial support, keywords, by force of law.
Yeah, and this is interesting because this is one, it's something, and again, as you know, I tend to move mostly in the middle on a lot of issues. But I will say that both in free exercise and establishment, because I'm not a fan of Smith or a number of other Scalia opinions, I rarely agree with Scalia on anything in the religion clause area, but I will say I think he's right about that. And the reality is you don't need coercion. Where I disagree is, of course, he would think that that makes the school prayer constitutional. Unless you have legal compulsion, it's constitutional. You know, I think Justice Blackmun and the other, the concurrences do a nice job of just sort of shooting that down. Because I think that there are, at least at that point, precedent as well as perhaps common sense in a way, which say that the prayer, whether it's compelled or not, its purpose and effect were religious. But I actually think Justice Scalia is right there. I mean, coercion was generally understood as whether legal compulsion by force of law, like prison, but some sort of penalty. Like you wouldn't, I think he might mention, you wouldn't get your diploma if you didn't attend or something like that. Right. At the very least, maybe something like that. Now, again, that doesn't mean this was constitutional, but I think it does mean that it's not the sort of coercion we're used to thinking about as a legal test. Also, and of course, he's not a fan of Ingle or Abington, so he doesn't really cite back to them. But you'll notice that in both Ingle and Abington, the court is very careful to point out that coercion is unnecessary, right? Justice Stewart's dissent on aside, the majorities in both cases are very clear that coercion is not necessary. I think they're referring to what Scalia is referring to by coercion.
Right.
One other note on that, there's another strain in the dissent that's interesting. And I wrote a book that addressed, it was actually the first book I ever wrote that addressed some of this. And Justice Scalia goes after the majority for using what he calls essentially pop psychology,
Right,
to show coercion. There's an irony to both sides of this.
yes.
When writing this book on school prayer and discrimination, where I was really focusing on what happens to religious minorities, I wasn't focusing on it purely as an establishment clause matter, but actually socially, what like a legal realist perspective, what is the actual impact of school prayer on religious minorities? And there is a ton of psychological data out there. And while there may be some disagreement over exactly how, the data overwhelmingly supports that this is actually psychological. School prayer is frequently psychologically damaging for religious minorities. But ironically, the studies that the majority cited don't stand for that proposition. They stand for a tangential proposition that's actually pretty heavily debated in this, even today in the social sciences. But there were a raft of studies that supported what the majority was saying. But maybe, and I bring this up in class, does that mean that Justice Scalia actually has a good point here, that maybe the majority shouldn't be in the business of this sort of psychological coercion? Or is this something that suggests that we really need to go look at our evidence and the fact that we could have experts that could do a good amount of testimony on that?
Except, and this is a generalized problem, except of course, assuming everything you said was right, the minute you get to the psychology, some justices might say you've now leaped out of Article 3,
right,
and you've now created everything that is critically important, either for constitutional amendment or for legislation, that is inherently a political choice, but cannot be, right, the expert scientist plus the expert judge creating an expert culture that they then run on a Frankfurter style case-by-case basis. You have the nightmare, right, that some people love this, right, but the nightmare that some people have, that in fact what you've then done is invert the allocation of power, so that ultimately this becomes a government by judiciary.
Yeah, the Dauber and Fry before it debate. I agree. You could see. I mean, I could certainly see. Well, today it would probably be a majority, but at that time, right, the dissent going down that road. I mean, the reality is, if you are going to use psychological coercion, then at the very least, we hope that a better job would be done with it. But yeah, I do see that of course the court was dealing with what was on the trial court record, but then I'm not sure that was really, as much before the court as in terms of the psychological information. I think the court just went there. So I agree with you. I mean, the battle of the experts question has been frequently cited as a reason why these things should really go to legislatures or through constitutional amendment, as you said. I mean, as long as Daubert lives or Fry before that, of course, we can have these sorts of expert battles, but you just kind of wish they would have done a better job of it in terms of the studies they cited.
No, exactly. But so here's a question. The majority really gives very short shrift to the notion of accommodation.
Yeah.
Again, in part because it got distracted. I'll say the word, it got distracted by coercion. But is it possible to argue that here again, the dissent might well have had a point that could have been better met by the majority in the context of an accommodation notion?
This is obviously a debate that folks like Mike McConnell have been engaged in with Steve Green and a number of people on different sides of this issue, is whether or not accommodation should play any role in Establishment Clause cases. We see this back with Justice Stewart's dissenting opinions in the 60s school prayer cases. Here's my sense of it as a religious minority, right? In this case, it so happened that it was a rabbi delivering the prayer. But the reality is that's very rarely the case. It's very rarely a religious minority delivering the prayer. It could be. But and even then the question is, well, what about people from other religious minorities? I think the problem with accommodation is it may make sense when you're accommodating a religious person or people or a religious entity for their own religious practices, right? That's why I'm not a fan of Smith. On the other hand, it's an entirely different matter to say that the government has to accommodate the will of the majority to impose their religious views or ideas on others, or that there's the sense of sort of group accommodation by government in a government facility, which is different than privately accommodating. It may actually have, it's a good question for another reason, and actually I haven't brought this up in class, but maybe I will. It may almost have like a through the looking glass moment going forward to what we're seeing with Hobby Lobby and some of these other cases, where the question is whether even these private accommodations should exist, where the accommodation may impact the rights of others. As Justice Ginsburg pointed out in her Hobby Lobby dissent, quoting Holmes, your rights stop at the next person's chin. And, I do think that accommodating the group, as Scalia suggests here, what you're doing then is you're saying the group has a right to practice its religion or whatever religion it views as acceptable in a government facility, even if that has a negative impact on religious minorities. Now, of course, Scalia disagrees that has any negative impact on religious minorities.
Right.
But look at how most school prayer, the first book I wrote was all about the discrimination that happens to religious minorities when school prayer occurs. And it's been violent, and it's been violent for a long time.
Right, but that gets to the core, and you mentioned it, and I'm glad you did. This connection, I think, between the concepts and the consequences of accommodation and the approach to the understanding and application of the concept of imposition. Yeah. If in fact you tend to view imposition narrowly, which appears to be what is constantly going on when you're dealing with the neutrality historical test. If imposition is itself a formal construct that is limited by the historical context in which it was created for constitutional purposes, then the imposition that you're talking about is extra constitutional and not, or ought not to be, a relevant element of the constitutional discourse, even if it might be a relevant element in the political discourse around it.
Well, I think the response is you cut off that last part, but say there's a fundamental difference between accommodating private religious behavior or religious entity religious behavior and using government facilities to create a group accommodation. In other words, that you could say that as a constitutional matter, even for textualists, theoretically, that's a distinction between the free exercise clause and the establishment clause. In fact, if you look at Stephen Carter's work of viewing it as a unitary clause, I think even within his approach, you might view that as a line that separates some of the conceptual elements of the unitary clause that might be a little bit different.
Right, but some people would not accept that line at all. And
yeah, of course,
right. And quite plausibly, for them, there's this public-private divide in establishment focuses establishment on the wrong thing. That indeed their view of imposition is another way of suggesting that the gaze for the construction of establishment has got it wrong, and that you shouldn't be looking at the state as a trigger. You should be looking at is the quantum of state action, which is the trigger itself, and that to substitute the state as an establishment fetish object then tends to automatically distort what they believe to be a much, much narrower perspective on both the constitutional meaning, not the cultural, but the constitutional meaning of imposition, and therefore the constitutional permission or space that's available for accommodation.
Yeah, and we've seen this, with Justice and a number of opinions that if you're doing Levy Weisman now in the book, you will be seeing these opinions. Justice Thomas's dissents in a number of cases point out the idea, this idea that the establishment, I mean, he's not sure it should have been incorporated, but even assuming it's incorporated, it certainly wouldn't apply to these sorts of situations. As you said already, Justice Scalia's dissent in this case raises that essentially. And, there's, I think a much more sophisticated version of that, with which I don't happen to agree, but which I think is just brilliantly written and has to be addressed, is Dan Kunkel's concept of the structural.
Yeah.
Right. And, this concept of the structural, view of the establishment clause. And so, and there's some great scholarship on that, which I think, it gives a lot of they wouldn't go quite as far as maybe Thomas does, but they do some of the things that you'll see in future cases from Justice Rehnquist, or sometimes Justice Scalia, and maybe in modern cases from Justice Alito. There you see that sort of background, exactly what you're saying, framing this as, we really shouldn't be worried that the state's doing something. As long as it's non-preferential, essentially, it's okay. The question is the structure of government being used or interacting with religion in a way that the framers would have viewed as problematic.
Exactly.
And so that is, I mean, look, those arguments are powerful arguments. I don't personally, and I've written about this, and I know you have as well. I mean, I don't personally agree with those arguments, but on the other hand, when you read particularly some of the really interesting stuff there, they are powerful arguments, whether reasonable minds can disagree.
Right. And yeah. we will see what the current crop of justices are going to do with this stuff. They may take the bait and run with it, or they may find something else, a different route to take to get them to a place that I think will be vastly different from the conceptual space within which Lee was decided a generation ago.
Yeah, we'll have to see. I mean, I think that, the one case coming up, obviously, that we have under the Establishment Clause in the coming term is the Maine voucher case. And so we'll see how that plays out. That may tell us something, although that may be framed more as a free exercise case, but how that that nexus arises, I think it's a really interesting question. You know, and particularly the one that is interesting to watch is Justice Kavanaugh, because when he was on the Fourth Circuit and then now also on the Supreme Court, he's always, he's very rarely found what a lot of people would view as an Establishment Clause violation that he views as an actual violation. But on the other hand, he has written with great sympathy towards the plight of religious minorities. And so it'll be very interesting to see if that's just essentially talking the talk and not walking the walk, or whether that, because he was a Kennedy clerk,
Right.
whether or not that leads him to roll with Lee. And it's just hard to say. And of course, Roberts is unpredictable on that as well. You know, and you know, I think we pretty much know Alito and Thomas, you know, on those issues. But and then the Gorsuch, Coney Barrett, you know, I don't have enough of at least as a judge of a case set to know where Coney Barrett would come out on the Establishment Clause, but Gorsuch doesn't. He's a little more Alito-esque, I think, in a way on those issues. And so, but it's just hard to say because you don't know, because there's also stare decisis. I mean, Lee's been around for quite a while.
It has been, but it can also be confined to its facts.
Yes. Yes.
Which would be the noble way of doing this, sort of like, to some extent, people have argued that is in a case where we're going to talk next time, the Wallace case might well have been confined to its fact, its peculiarities. But and the other case we're going to talk about next time, Santa Fe, I think that may be the real battleground here. Oh, no, exactly right. Exactly. And in fact, I just taught that today, and that was the tenor of the discussion, looking at the battleground. But I suspect for perhaps for Kavanaugh and the others, the middle of the right, it may touch on whether the result is a permitted governmental privileging of religion as against the secular versus a privileging of a particular religion as against others. So depending on how the way this comes up, if it's framed in that way, the case may go.
The suggestion is they're moving in what you would call a non-preferentialism direction, which is that you can favor religion over irreligion, but not one religion over others. But they're not there yet. I mean, American humanists didn't go that far, right?
Right.
It went most of the way. What they're doing is they're bringing it in from the free exercise clause by expanding Lukumi Babaluai and then Trinity Lutheran way beyond their boundaries in the Espinoza case.
Right.
And so, you know, they're sort of back dumping it in from that, because, you know, and we'll see, because there's a case before the court now that will address the main voucher situation, which is a free exercise, but also an establishment, and potentially as federalism issues.
Right. Going back to the unitary theory of the free exercise and establishment.
Yeah,
we will see. It's just a laugh a minute. All right, we have probably just exhausted the patience of our listeners. So thank you all very much. Last words.
Sorry about that, listeners.
No. Last words, Frank.
I think, you know, for those of you teaching Levi Weisman, for those of you studying it, it's a fascinating case. And you know, look at all, I think this is true it's one of the reasons we leave a lot of the concurring and dissenting opinions in. Look at all of the opinions, because each of them teaches you something. And each of them, you know, I edited out the baccalaureate concurrence from Justice Souter simply because we're trying to keep the book at a relative pace. But even that one, if you have time, you can go look at it. It's kind of interesting. But the reality is, each of these opinions you can learn something very important from, that reflects, as Larry's excellent questions pointed out, that reflects on where we're going with the law now. So I would say just enjoy. That would be my last word for this case is enjoy.
Right. And mine is, we're living in the age of oxymoron, where we are conflating. In fact, when you look at these cases, you're looking at the oxymoronic in the sense of the proliferation of the incompatible, but within a plausible unitary system, and how those engage with each other, learn from each other, are molded by each other in what appears to be now a multi-generational conversation, adds a tremendous amount of conceptual spice to the lawyering and the realities and the applications of these cases in the real life situations in which we find them.
Yeah, we can look at this whole thing. I like the way you put it as a multi-generational conversation. If we look at Engel and Abington as a conversation starter, so to speak, Emerson would have been, but if we look at it, the big concern there was navigating religious diversity in a pluralistic society. Ironically, there were no religious minorities on the court at that time. But as we've moved forward today, that conversation has changed quite a bit in the current generation of justices who may be further from the earlier justices in the early 60s than any time in between. And from that perspective, Levy Weisman from 91 and Santa Fe v. Doe from 2002 are maybe Lee was 92, but anyway, but the reality is that those are they're kind of middle ground parts of that multi-general conversation.
Exactly right. Well, anyway, thank you very much. It's a great conversation. We could go on forever. Yep. Join us next time when we look at Santa Fe and Wallace. Thanks again, Frank.
Thank you. Bye-bye.